From the Library of Congress in Washington, D.C.
So welcome everybody. This is section 6, which is on new ways to disseminate content and the impact of moral rights. My name is Maria Strong. I'm with the Copyright Office. And we're joined here today with, to my immediate left, Scott Martin, who's Executive VP of IP for Paramount Pictures, followed by Alec French of Thorson French Advocacy, representing today the Directors Guild of America. Next to him is Mr. Stan Pierre-Louis, who is Senior Vice President and General Counsel of the Entertainment Software Association. Next is Roxana Robinson, author and President of the Authors Guild. And at the end is Mr. Chris Castle of Christian L. Castle Attorneys. Today, as we've heard, we have the opportunity to sort of wrap up all of the exciting things that we've heard in the panels before us, but also to really hear more about the importance of contractual transactions and distribution practices. On this panel, we have representatives from private corporations, from guilds, from organizations representing individual authors. So this is an opportunity for us to explore with you some of the issues that have been raised today, as well as at the end, we'll maintain some questions time for you all to ask us. So with that, what I'd like to do is open up with a question for all of them, and we'll go down the line, and then we'll start up with more individual questions just to get the conversation going. So for everyone, the question that they have to consider and answer for you all is, what are the most important elements present in your industry that contribute to supporting the concepts of attributing authors' interests in the final work and for protecting the integrity of the author's contributions? And what are the biggest challenges that you face in your sector? And with that, we're going to start with Mr. Scott Martin.
And I should probably note, Steve Marks, who was supposed to be with us, is under the weather, which is why he's not here. I really wanted to have his placard in front of me, because then I'd have complete deniability. And everyone would say, did you hear what Steve Marks said today at the Copyright Office? But they wouldn't give it to me. In order to answer the question, I brought some visuals because I come from a visual world and I can't speak without images. And what I wanted to focus on in answering Maria's question is something that we haven't really touched on a lot today, which is collective works. We've been talking a lot about individual works, so works of things like books, magazine articles, photographs, sculptures. I come from the world of collective works, which raises a lot of issues that we haven't really gotten into today. And so what I wanted to do was look quickly at how some of these issues are dealt with in Europe. There you go. So, do European moral rights apply to U.S. citizens? The answer is yes, no, maybe. So even as we go through these, when you're looking at countries that are the home of hardcore statutory moral rights, there's not a lot of agreement. For foreign work, which country's law defines the initial holders, who is the initial holder of the moral rights? In other words, choice of law. In some countries, it's the local law. In some countries, it's the country of origin. Some countries, it's kind of unresolved. Who gets the moral rights in a work created by an employee on the job? In fact, a work made for hire. Some countries, it's the employee. Some, it's the employer. In still others, there are no moral rights in a true work for hire. Who is the moral rights author of an audiovisual work? It's all over the place. In almost every country, it includes the director. Some countries include the composers, some do not. Some include the producer, some do not. Several, as you see here, France and Brazil include possibly others. In some countries, it's undefined. Who has the moral rights in a performance? Some countries, it's the performers. As was mentioned, I think it may have been Duncan who mentioned it this morning. In some countries, there are no moral rights in a performance. If there's more than one holder of moral rights, which you will have in a collective work, can one holder alone block an act? In some countries, yes. Some countries, no. Some countries, unresolved. after the holder's death, do moral rights survive? This is an easy one. Yes. In every country that has moral rights, they always survive death. If post-death there's more than one successor, can that successor alone block an act? In some countries, yes. Some countries, no. Some countries, not so clear. Is a contractual agreement to waive moral rights enforceable? Can you waive away your moral rights? In some countries, no. Some countries, yes. Some countries, no, but. What about limiting it? Can you agree not to waive it, but to limit it? Again, some countries, no. Few more countries, yes, but with limitations. Usually where it's a yes, but. It's a yes, but for a very specific agreement to waive a very specific use. So what all this does, I think, is highlight the complicated nature of moral rights when you're talking about film and television and collective works. And that even in the countries that have these robust, long-standing statutory moral rights regimes, there's not agreement on how you deal with it. So what is the best way to deal with it? My view of the solution is, and again, just talking about film and television, that effective collective bargaining is the best way. And I'll stop there because I think a little later we're going to talk about collective bargaining and how it actually works.
Thank you, Scott. Alec?
Sure. Well, the Directors Guild of America has long believed that due to the unique nature of filmmaking, its members deserve recognized statutory moral rights. I think the best way to explain this, actually, or to explain why, is I think a really eloquent letter that the Directors Guild and the Writers Guild submitted to the House Judiciary Committee for a hearing they did in July 2014 on this. Just quote from it briefly. Funding a motion picture is not the same as actually creating it. Holding a copyright does not confer artistic talent on a corporate entity. Rather, it is the writer and director's creativity and vision that is decisive to telling a story. A myriad of intensely personal and visionary creative decisions give life to the motion picture. Creative expression, like authorship, is a human, not a corporate quality. We believe that authorship has to do with creative vision, and that moral rights reside with those who have that vision. So that's kind of the starting point for how the Directors Guild looks at these issues. And then to the second part of the question Maria asked, I think the biggest challenge that directors face in asserting moral rights is a combination of two facts. One, there are no meaningful statutory protections for moral rights in the U.S. And two, and this is what Scott pointed out, in the U.S., motion pictures are considered works made for hire, and so directors effectively don't have any statutory right to control the motion picture after creation.
And I just add something to what Alex said, that not only do we not have moral rights legislation in this country, something we haven't talked about today that affects the DGA in particular is we have anti-moral rights legislation, which is the Family Movie Act of 2005. That I think Mary Beth just passed out, that creates a right to alter a motion picture to take out the smutty bits.
Hope that wasn't a lead-in. ESA represents the video game industry and really its U.S. Interests, both on the U.S. publisher side and the game consoles. I'll touch a little bit on international, but I'll veer as much away from it as possible, since that's the province of some other groups. The interesting thing about the way video game companies are set up is that they are partially like film studios, television studios, record companies, and they are partially like software companies. So on the one hand, there are third-party collaborations that occur where someone's created a particular property, and that either gets acquired or gets put into a larger work, or maybe it is the work that gets distributed. On the other hand, many video game companies actually hire everyone, including the composers and everyone else, and so everyone's an employee. And so you've got this dichotomy of both how specific companies are run and how the industry may work in an acquisition phase or otherwise. But under both models, what becomes difficult is distribution if you need to get permissions all along the way outside of that initial model, because under the U.S. construct at least, work for hire and licensing of that nature helps in terms of flexibility and setting expectations, assembling the rights. In other countries, as I talked to some of my colleagues abroad, particularly in France, the key there is to have good relationships with third-party authors, because moral rights regimes are so much stronger that you've got to make sure that you're creating those relationships to get things moving, and that's ends up being the key beyond any contract, because if people feel like you're using their work in the positive light and in the way that they intended it to be portrayed, things get approved much more quickly. And so the American side of companies, when they look at what happens, particularly in Europe, are glad not to have a moral rights regime, because it helps to be able to assemble those rights and move it forward. And I think the challenge really is, how do you change all the expectations that have built up over time under the construct, particularly if you have a company that hires lots of the collaborators that make up a video game. And I think that's going to be one of the challenges, is how you maintain expectations while looking at the way that companies are really set up in the U.S., at least at our industry.
So I'll talk a little bit about moral rights and also how they affect the public. Somebody raised that question earlier, saying, how does this benefit the public if we're protecting the moral rights of the creators? We've heard that the moral right accrues to a work that's created by a single individual. Only that individual could create this particular piece of work, this book. I'll talk about books. And so these people, and as you have heard, the Supreme Court has decided not to hear our case, the case that we brought up against Google Books, and I'll talk about that a little bit in terms of the way it affects our authors and their works. So that one of the things that we believe should be contained within the idea of moral rights is that you have control over your work. You created it, and you should be able to control it. At the very least, you should be consulted. Your permission should be asked for if your work is going to be put into an enormous database and disseminated to the public at the will of the aggregator, and it will have nothing to do with you. So we feel that that is a real problem in terms of the moral right of the creator. So what has happened, that the moral right and the fair use notions have become sort of blurred. So what Google Books did was to take 20 million texts without the permission of the writers and put them into a database which is accessible by anybody. So I'll just give you, I'll describe a situation in which that usage is made and how it affects the public and how it affects the writer. So we have a student who needs to write a paper on Anna Karenina. She goes to her computer because it's easier than going to the library, and she types in to Google Books, Anna Karenina, Leo Tolstoy, divorce. She only needs to know a little bit. She wants to write in her paper about the fact that Leo Tolstoy's sister had a disastrous affair. She had a child out of wedlock, and she considered suicide. The student wants to know when that happened, when Tolstoy died, and when the book was published. It's very easy on Google Books. A woman called Rosamund Bartlett wrote a great biography of Tolstoy, and it's there. The student signs in, finds those facts, and signs off. She doesn't need to buy the book. The library doesn't need to buy the book. So it's done. However, Rosamund Bartlett, I don't know her, so I'm assuming this, but I'm assuming that she took at least 5 years to write this biography. She went to Russia. She interviewed Russians. She might have learned Russian for this biography. She read critical works. She read Tolstoy's works. She created a unique version of Tolstoy's life. She proffered that to a publisher. The publisher gave it peer review. The publisher edited it, copy edited it, made it into an object, and put it out into the world for sale. Now, as an economic model, the work of those two people cannot be duplicated forever if there are no sales transactions. Libraries traditionally have been the great financial supporters of nonfiction. So academics have depended enormously. People who write books for the academic public have depended on libraries and the library systems. But Google Books can take the work of anyone they want. They have taken the works of 20 million writers and put it into a database that gives no compensation to the writers or to the publishers. That's a model that cannot be sustained, and that will cause harm to the public. If we cannot keep producing excellent works that are created over periods of time through a great deal of research and intellectual content, that are peer-reviewed and properly edited, the student must find the right information. She cannot rely on Wikipedia or somebody's Facebook page. That is not going to do it. So she has to go to a professional source with material that is absolutely reliable. She goes to a book that's been published by a professional publisher. Interestingly, Chris sent me an article about Google Books that was published in 2009 when they were being accused of doing this that was in a way that was damaging to the writers. And Sergey Brin, who was a co-founder of Google, said ingenuously, "We feel that this Google Books is part of our core mission. This is news to all of you. There is fantastic information in books. Often, when I do research, what is in a book is miles ahead of what I find on a website." Who knew? But the point is that books are actually necessary for a society. It is necessary for the culture to have access to them. And in order to keep producing good books, we have to have compensation. That's all.
Thanks, Roxana. Chris?
Well, I would just add that one of the things that doesn't get discussed a lot with Google Books is the non-display uses, also known as corpus machine translation, for those of you reading along, which is how they have such a good translation engine, because when you teach a machine languages, you do it by comparing text strings. And one of the ways you get a lot of text strings that are identical phrasing is to have books that have been translated into a variety of languages, which the publisher paid for, which the author approved. Right, so anyway, I can go on for a long time about that. So I wanted to talk a little bit specifically about songwriters and recording artists who are subject in one way or another to, some might call it the boot heel of the government, or others might call it compulsory licenses under Section 114 and 115 of the Copyright Act, or what I would call near compulsory licenses under the ASCAP BMI consent decrees. So while there are reporting requirements for royalty accounting in these compulsory licenses, there's virtually no attribution requirement in them. So for example, if you were to check, I would put even money on this, that the most used artist on SiriusXM is various artists. The reason it's various artists is because Sirius doesn't go out and buy the album for every hit that they want to play on the radio. They go out and they buy a compilation record. And then they rip that compilation record, which they're allowed to do, into their system. And there's someone, usually a minimum wage employee, who we also used to call a teenager, who is doing data entry, right, in their system. And they come to who's the artist, and they look on the label copy, and it says various artists. So they put in various artists, right? And there's nothing that requires Sirius to do much more than that. So consequently, when that kind of reporting comes to an organization like Sound Exchange, or somebody who has to figure out who to pay and how much to pay them, they're looking at various artists and they're trying to figure out, well, what does that mean? And so then they have to go back and take the song title and so on and so on and so on. Whereas if there had just been a requirement of proper attribution for the artist in that case in the first place, that wouldn't have been a problem, or would have been less of a problem. And it wouldn't have turned so much on how that data entry person was feeling that day. I would also point out that no digital retailer requires the delivery of songwriter credits, producer credits, or musician credits. So iTunes has no requirement that anybody, any label that's uploading, or as they call it rather discomfortingly, ingesting music into their system, actually provide them with substantial credits. In fact, there was not even a place for composer credits in the iTunes info section, which you can check when you go home, that even had a slot for composer. Now they have a slot for composer, but that's sort of voluntary on the part of the record company as to whether they're going to actually input any data there, and there's nobody that checks whether it's right or not. This is really bizarre when you stop and think that record companies have extraordinarily detailed label copy management systems where they keep track of all this. Because when you put out a CD, for example, someone, namely the artist usually, approves all the credits that go on that CD, and they want to have at least the songwriter names. They may put the publisher names on there too. That lives in the background in the label copy management system. So if you see songwriter names on the label, on the actual inlay card or the actual credits in the CD, somewhere in the background in the label copy management system, because it feeds into the mechanical royalty system, there's the names of all these publishers that go with those songwriters. There's producer names, there's musician names. There's a whole generation of people that's growing up not knowing who played on what, and that's mostly because there's really no attribution requirements that are meaningful for any of these digital retailers, whereas on the label side, you would tend to have them because they still put out things in physical. There's going to come a day when that's no longer the case, right? So we haven't got there yet. We're not at that inflection point, but that day is coming. Yet, on the song side, the songwriters can't say no. They have to license. They have to license under those conditions. They have to license regardless of whether the person has paid their mechanical royalties, knows who they are, knows who to pay. That person can continue getting compulsory licenses. If they've never credited one songwriter, they can continue getting compulsory licenses. Now, you can always sue, but as we've heard earlier today, for the individual creator and the individual songwriter, particularly as we go circling down the drain, in the declining revenues of the digital reality of the music business, those people aren't going to sue anybody. So I just wanted to point out there's this nexus between that would be, I think, pretty easy fix. Although I'm sure the Copyright Office is in full compliance. But it'd be a pretty easy fix to say, well, if you're going to get a compulsory license, then here's what else you have to do too.
Thank you, Chris. Thank you all. What I'd like to do is, we've had a lot of conversation today on a couple of issues: contracts, technology, the role of fair use and how it plays into moral rights, questions about commercial speech. So as follow-up on what Scott started, and I'd like to kind of follow up with everybody a little bit more on what do you think the key contractual terms or elements that you have in your industry that offer these moral rights style of elements. I mean, we've heard mentioned already some of the collective bargaining and some guild contracts, but if we can maybe start a little bit with that, and if you can be specific on what are the elements that, support that kind of moral rights-like solution.
Well, in my world, which is governed by collective bargaining, which, as I said, I think where it's available and applicable is the best solution. It comes out of the guild agreements. So, for example, the WGA agreement, the Writers Guild Agreement, specifies the writing, and as you know, we cannot stop ourselves from hiring writers on movies. It's never good enough to have one. You got to have 2 or 3 or 4. And then it becomes an issue over who gets credit, who gets story by credit, who gets written by credit. And all of that is governed by the WGA. We submit a notice of proposed credit, but it's the guild who decides who gets the credit, which is why no matter how powerful Michael Bay is as a producer and director, you will never see him get a writer's credit on a Transformers film because the guild will never give it to him. And just by a show of hands, how many people know the difference when you see a movie credit, a writer's credit, for 2 names, and there's an A and D between them or an ampersand between them? How many of you know what the difference is? I see 1.5 hands. An ampersand means that they wrote as a team, and an and means they wrote sequentially. Even a copyright moral rights aware group, it doesn't know that, but believe me, the writers know that. Similarly with SAG, with the Screen Actors Guild for performers, we have a whole list of requirements that there has to be a separate card for the actors. It has to be readable in terms of color, size, and speed, so we can't fly past. We are required to list a minimum of 50 actors, and that's what's called the SAG cards, one of the first cards you see in the end titles. There are very significant financial penalties if we either don't do it at all or don't list all 50. There is an obligation to correct a print. So if we get it wrong, we have to correct prints even after they're in distribution. Beyond that, we are required by the collective bargaining agreement with the Screen Actors Guild to obligate exhibitors, distributors, broadcasters, not to cut the credits off. So AMC theaters, in order to squeeze in one more showing a day, can't cut that 5 minutes of credits off the end of the film based on our contractual obligation with them. Those are levels of protection that you'll never get from a statute. And that's why I think where it's available, as it is with commercial film and television, the direct negotiation is the best route. Just to say real quickly, there's also integrity issues, integrity rights that come out of this. We've been focused a lot on attribution, but the Screen Actors Guild has a reuse clause that we cannot reuse a performance in any other work without the permission of the performer. If we do it without the permission of the performer, there's a financial penalty which is 3 times the daily rate for the actor times the number of days it took to film the scene, times the number of actors in the scene. So it's a very significant financial deterrent. But at the same time, there's a balancing because I talked about the veto right. And how does it work statutorily where you have a collective work, one author says, I'm cool with this new use, and another author of the same work says no. Under the Screen Actors Guild, if there's a holdout, basically all the actors consent to the new use, consent to the financial terms, but there's one holdout, we can submit it to the SAG Board of Directors. And the SAG Board of Directors decides whether or not they can override that one holdout actor. So there's a mechanism, and it's a mechanism that's run by the performers to get around that.
Others?
I guess just following up in the movie vein, Scott's absolutely right. Through collective bargaining, some of the talent has managed to secure creative rights. As I've become familiar with over the last couple of weeks, it's all right here in the Creative Rights Handbook for Directors. And there are things that are facsimiles of rights of attribution and rights of integrity that you'd find in a moral rights regime. On the credit side, directed by is, the attribution that's given to director. There are very specific rules on the lettering, the size of the lettering. It's either the last credit you see before the movie starts, if the credits are at the beginning, or the first credit you see at the end, if that's where the credits are. So that is a facsimile of a right of attribution, and there's a facsimile on the right of integrity side. There's something called the director's cut, where, again, this through collective bargaining, directors have the right to present the producer with the version of the movie, their cut, after a set number of actual weeks that they're allowed to prepare that cut, and they're allowed to present that to the person in the production studio who has authority basically over the movie, not over someone below him, and no one can cut behind, kind of change it before it goes to that person. So there are, hard-fought creative rights that are part of the collective bargaining agreement that are similar to what you'd find in a moral rights regime, but I want to be clear that's still doesn't mean that Directors Guild feels that it's complete, that all the rights that they'd like to be protected are protected against all the parties they'd like them to be protected against.
Yeah, in our industry, it can vary wildly depending on the company, how the game is made. Oftentimes, there'll be a lead designer who leads the effort. There might be a producer, which I'll talk about in 1 second, but there can be, there's been reports that Grand Theft Auto, one of the big games put out by Take-Two Interactive, it took 300 people to put that game together. and they roll these out every few years. And you can imagine trying to figure out all the various credits of someone who came in for this portion or that portion can get kind of complicated. But oftentimes the lead designer or designers will be the ones who get a lot of the credit. In Japan, there's a phenomenon of producers. Those of you who have not played modern games probably aren't aware that they feel very much like reality or like movies. They have storylines, they have plots, they change depending on what your character does, and they very much are cinematic. At last year's E3, which is a big expo for the retailers in video game space, where retailers see the new games coming out, there were lines out the door for a few of the Japanese producers who were visiting because people rarely get to see them here. And so they really are treated like rock stars, and the likes of J.J. Abrams kind of comment on their works and play their games. But it's very cinematic, but that's where it becomes complicated. Is it more like a film or is it more like software? And it will be very dependent on the structure of the game and the structure of the company.
The best protections that authors have traditionally enjoyed has been that of copyright, and that has protected the work until we entered into the world of digitalization and electronic publications. So authors have lost a good deal of protection that copyright offered once their books can be taken without permission and put into other people's databases and disseminated. What we would like to do at the Guild is to create a system that will offer some kind of market-based collective bargaining, collective licensing, and we're working on that. Other than that, there are other issues. Generally speaking, authors do have the rights of integrity, but we're seeing some kind of odd sort of piratical incursions into people's books, and we're seeing people's works translated into foreign countries, into foreign languages and sold there, sometimes with a gender reversal. So it will be a romance book, heterosexual, and it will turn up in Germany being homosexual. Same book, same title, different author, same, but a pirated version. So these are things that are going to be very complicated to deal with. I don't have a solution right now. Where every time something new comes up, we have to figure out a different way of dealing with it. So I think the digital era is just going to keep on offering new possibilities in every direction, directions that we want to go in and directions that we don't want to go in.
Speaking of, I'm going to sort of speak generally about both songwriters and recording artists because you get at it kind of the same way in their deals. So if a recording artist is signing with a major label in particular, but really any label, and if a songwriter is signing like a co-publishing and exclusive administration agreement with a music publisher, you typically will ask for something called marketing restrictions. And these are sometimes commercial in nature, but more often than not, they are more in the integrity range. So you would say, for example, you can't license my recording for advertising, really of any kind by the time you get through all the different examples. You can't license my recording for a sample. You can't license my recording in certain types of motion pictures or television. You can't release my recording in certain kinds of compilation records. So there'll be a number of these exclusions that the record company just is agreeing up front that they won't do. Now, that really comes across in the first draft as a general rule. Now, there are things that are leverage points that go beyond that. And depending on the artist may have some particular bugaboos, that they want to see written in that contract, even though you say to yourself, there is no way the label's ever going to do this, but they want to see it. And this, some of these are not trivial either. I mean, there was a time, before the end of apartheid where it was absolutely standard to have your artists asked to have their records not distributed in South Africa. and you'd get it. No one would argue with you. The leverage point really comes in more whether it's during or after the term. So I'm not saying that there's not a sense of leverage and how bad they want to sign you, or if it's a renegotiation, how bad they want to give you new terms. So realize if you say it's during the term, then that means as long as that artist is a current roster artist, let's say, or is still in contract with a publisher, then these restrictions would apply. If it's after the term, that means forever, right? So when you stop and think that record companies and music publishers carry unrecouped balances at historical dollar figures, do not charge interest, and those will never increase based on inflation, telling somebody they can't ever license your recording for something that might be a nice payday that would help you get recouped and help them recover their investment is kind of a tough conversation. But it can be done, or it can be done in a limited number of circumstances at least. So that's sort of how it's addressed, similar to the way the guilds do it, but it's addressed in a one-off because recording artists don't have, featured recording artists don't have their own union. While they may be members of the AFM or they may be members of SAG-AFTRA, they don't, as in their capacity as featured recording artists, have anybody negotiating on their behalf in a collective bargaining agreement.
Yeah, I'd like to follow up on your point there, Chris, about market restrictions. And earlier sessions today have talked about issues involving circumstances where the author may, find their work being used in objectionable circumstances, whether it's a commercial speech issue, a political ad. I was curious to know, to those of you who are, copyright owners, maybe not the initial individual artist, but can anyone chime in on your thoughts about how you want to, or how do you control or somehow guide uses in those cases where maybe circumstances involve objectionable contents that you might not want to see your work associated with? Your final work product. Anyone can chime in. Doesn't.
Well, I can talk about samples, right?
Yeah.
So when I used to work at A&M Records in Los Angeles for a number of years, and during sort of the 90s, where we had a lot of sort of the rise of hip hop, and we had a lot of sample requests that would come in. And so what we decided, we had to decide what we were going to do as a label about the sample requests and whether we were going to, how we were going to approach it. So basically what I decided to do was I said, okay, I'm going to take my cue from the artist who is being sampled. In other words, our artist. And if that artist, regardless of whether they have the right, regardless of whether they're in contract, regardless of anything, if that artist wants to be sampled in this way and have their recording used in the requested way, then I will back them. I will then take over the commercial terms, so I'm not completely giving up our control, but I will take my initial cue from them. And I don't care how much money they offer. I don't care, what it is. If our artist doesn't want to do it, we're going to back our artist. Or alternatively, if our artist does want to do it and I don't want to do it, which is what happened with Sting on Every Breath You Take that Puffy sampled, I thought, that's like karaoke, man. I mean, why do I want to do that? But we did it because Sting wanted to do it. And I said, okay, in for a penny, in for a pound. That's how we do things around here. But we didn't have to, right? We made a conscious decision that it's more important to us if we ever thought enough of that artist to sign them to A&M Records, if Herb Alpert and Jerry Moss wanted to be in business with that artist, then we were going to back the artist in that situation and let them control how they wanted their persona to be replicated.
Thanks. Others?
I think because of the season we're in right now, where you hear some of these claims is when works are used in political advertisements. And I think it's more often with music, when a candidate tries to use an iconic song as sort of their anthem at rallies. And you've heard about Bruce Springsteen going after politicians who've done this. Neil Young has gone after some people. It occasionally comes up with movies and TV where clips are being used in advertising. I would say most of it is in local campaigns, school board campaigns, local mayoral, where they're creating the campaigns themselves. There's not a big budget, and either they don't have copyright or trademark advice, or they just don't think anyone's ever going to see it. When we do get complaints in those situations, 99% of the time it's from the opponent in the race, as opposed to the talent. And for us, it's a little tricky because there is some, our works are generally not being used as like a theme of the campaign the way a song might be. So we're not as concerned about passing off. If you're talking strictly about copyright, it might be a good fair use argument. We also worry about going after somebody who then gets elected to a very high office. I think in the 24 years I've been at Paramount, I remember one incident where we went after a national campaign, and it's because one of the most iconic, famous directors in Hollywood, his granddaughter, who actually moved in with him when she was 8 years old because she once told me that he was a lot more interesting than her parents, was very upset about, in the last election, what a Republican running against Obama was using a clip from one of her grandfather's movie and altering the clip. And this individual is a fairly well-known lifelong Republican, so it wasn't even a political thing. She was very upset about her grandfather's work being altered and misused. And we contacted the campaign. At that point, we didn't know who was going to win, so we were very friendly with them. And they agreed to stop running it. So we do ask.
Yeah, Ellie.
Yeah, I mean, I guess I'm going to come at this a slightly different way because objectionable is in the eye of the beholder. And Scott mentioned the Family Entertainment and Copyright Act of 2005, which I had the great pleasure of working on when I was on the House Judiciary Committee. And that's a case where directors found what this company, ClearPlay, was going to do with DVD movies to be objectionable. They created software that was going to enable the consumer using the software to excise, as you said, all the naughty bits, sex, swear words, could have also, in another generation of the technology, excise violence or whatever was considered objectionable. Well, to a director, obviously, and you talk about right of integrity and attribution, one, they don't maybe want to be associated with what's presented on the consumer's screen that is not their artistic vision, or two, they don't want to let someone do this, basically destroy their movie and their vision of their movie. Now, the problem is that at that point in time, the studios did not want to take a case against ClearPlay. The copyright case probably wasn't a very good one, and it was also a politically charged time, so going against companies that are trying to clean up movies wasn't the politically smart thing to do. But that left directors with really no recourse because they don't have statutorily recognized moral rights. And they did bring a Lanham Act claim that wasn't, they filed a suit. And of course, all this ended up exploding into legislation that actually, as Scott said, rolled back, made things worse for directors. But the point, and I heard this brought up, I wasn't able to be here all day, but clearly one thing that's been discussed, and this is the core of the concern, is in a collective bargaining agreement with the studios, directors can secure certain types of rights, attribution, integrity, and can potentially even have those rights extend to parties with whom the studios are in privity, and there are areas where we've done that. But with regards to a third party that has no privity with the copyright owner, directors don't have any ability to protect what they consider to be their rights of attribution and integrity. So there, really, when they see something objectionable, there's not much they can do about it.
And I always thought that was a very interesting act by Congress, to say that you have a right to watch a movie the way you want to watch it, as opposed to just not watching it at all. When we were making the last Jackass movie, and I would come home at dinner and talk about the unbelievable things the Jackass boys were doing that day, and my boys, who were in elementary school at the time, would say, "Daddy, when do we get to see the movie?" And the answer was, never. And that should be, actually the answer was, you can watch it when hell freezes over or mommy goes out of town. And about a year later, my wife went out of town, and one of the boys said to me, "Okay, we're watching Jackass tonight." And I said it was a joke. They said, "No, it was a contract." So clearly, there's a future lawyer in the family.
Just to follow up, earlier today, Professor Ginsburg, made some interesting observations on the possibility of taking a new look at the first prong of the fair use doctrine. What do you guys all think about what she said today, and how might that play into your issues in protecting moral rights for your constituencies, to the extent I'm saying moral rights like?
One thing is interesting about that concept is I think there are a lot of different impediments to getting moral rights legislation in this country. But one of the big ones, I think, is the one-size-fits-all mentality. And to come up with a statute that works for a photographer or an individual writer, but also works with a collective work or work where there are very strong collective bargaining rights. If you try to have one size fits all, you're not going to satisfy all of those. And even when you look to the European examples, essentially they do not have effective collective bargaining in Europe for writers, directors, and actors. And that's partly for antitrust reasons, that they're not allowed. My wife for many, many years was head of the International Federation of Actors in London that worked on unionizing performers around the world, and it's a real challenge for them not to organize, but to bargain collectively because of antitrust laws. And one thing I like about the idea of working it into the fair use factor is it's not one size fits all. You would be able to look at things like, is there a collective bargaining agreement, or is it a collective work? So I think that's an interesting concept.
I think the other thing there would be, what is the scope of what we might call moral rights? So as I said before, in the US it's different than in Europe for our companies, where on a moral rights question, if there's someone who's owed the right of attribution or integrity, they confer. In the US, the issue doesn't come up as much, but what does come up are right of publicity claims. In cases in which real life people claim to be depicted in games just because their numbers, weight, size in a game might be similar to how they actually played, and the position might be the same. And how do you deal with that? And is that something that gets codified in some different way than the way that it's been dealt with now? And the way it's being dealt with now is actually rather confusing. I think there was a cert petition that was denied a few weeks ago in the electronic arts case, but that would have been a nice way to try to figure out which of the 5 various tests was the one that was most applicable depending on the jurisdiction in which you bring your claim or reside. And so I think scope is going to be very important there as well, because you're dealing with not only with personalities but historical figures and all kinds of depictions that might require the type of licensing that might make certain games not feasible to make.
I agree with the idea that it's not going to be one size fits all. And for writers, I mean, what we're seeing is this gradual dissolution of the notion that writers have control of their work, like other creators. And the idea of moral right is an inherent one. It's something that you can't lose. This is something that you have created. It didn't exist before it existed in your mind, and you have a right of intellectual ownership over that property. And we're seeing that right being drained. And so, for example, with our authors, all of whose works were put into this database without permission, the fact that piracy exists, so that the onus now, the burden now is on the writer to try to track down the pirate sites over and over and over and request takedowns, and the pirates simply put them back up. So the idea of moral right, a kind of moral ownership of your work has sort of vanished. So I think we're going to have to see more attention being given to that notion of inherent right that the creator has, and which cannot be taken away from him or her. And we have to figure out solutions, collective licensing rights, and situations in which it's not up to the writer to try to track down the pirates all across the world and to issue takedown notices. There has to be a better sense of protection for the created works.
I think you'd have to square the lens case with Article 27 of the Universal Declaration of Human Rights, which, in the Ninth Circuit, we do a lot of considering, but there's no consideration. So I think that David Lowery actually wrote a comment, and I will speak for him, hopefully correctly, as he had to leave, wrote a comment on the 512 study that the Copyright Office is doing, where he said that the way he reads the lens case is he will essentially, as an individual copyright owner, have to go out and get a legal opinion every time he sends a takedown notice to make sure that he's properly considered fair use aspects of the use by the downstream user. So, how the moral rights issue would fit in, if they don't, if that's the law, and if the law is that Google it's fair use for Google to copy 30 million books, it's really hard to say exactly how moral rights would, of any kind, would fit into this. But the reason I mentioned Universal Declaration of Human Rights is because that article essentially acknowledges, although it's the Universal Declaration of Human Rights, so I don't know how much anybody, legally is really empowered by that, although it's certainly a relevant document for the good and evil aspect of this. That article essentially states that everyone is entitled to the moral and material benefits of their work. So, if we're going to go through and explain why the benefit is to the public, for what the benefit is to the public for moral rights, then let's start at Article 1 and kind of work our way down and see how we do.
Thanks, Chris. I think we've run out of time for questions here from the dais, but we are going to open it up to the floor, so if the mics can get ready. As the mics are coming to you, I just wanted to let you know I received some news that the resale royalty case in California was dismissed this afternoon. It was, apparently the case says it was preempted by first sale. So for those of you who are following royal rights, resale royalty is what is sweet. Litigation, there's the second interesting piece of litigation news today. So we open this to the floor. We did not get a chance to talk about technology and CMI, so perhaps folks from the floor might have a question. I'm looking to Ben Ivins.
Question for Chris. You had, understand correctly, we're noting that neither compulsory licenses nor collective agreements, ASCAP, BMI consent agreements address this issue. Do you know if the songwriter community has ever sought either of those to be included? I mean, have they ever said in the ASCAP BMI negotiations, we want to negotiate this? Have they ever talked about, 115 or whatever, saying this should be an additional element, or had they not pushed that?
I'm not aware of it, but then again, the compulsory license rate was 2 cents for 65 years or so, so I don't know why that is, but I'm sure someone has an answer for it, but it does not mean. Given that it would be, if you just applied inflation to the 2 cent rate, it would now, I think the compulsory license rate would now be something like 85 cents instead of 9.1.
Any other questions out there? Can't see. Well, with that, let's stay on tune and let's thank the panel for their participation. And thank you all very much. We're going to start with the close-up session right now, so our two moderators will come right on up. Thank you so much.
This has been a presentation of the Library of Congress. Visit us at loc.gov.